in 72 special contracts. Today we will try to learn a new topic, means differences between the two important contracts called indemnity contract and guarantee contract. So let's have an idea about the differences, whether there is any difference or there are lots of differences between both the contracts. Let us try to elaborate them. Definition we have already discussed in the previous session. Let's have an overview about the contract of indemnity. Indemnity contract are defined as under section 124 of Indian Contract Act, which specifically focuses on what, sir? The promisor undertakes to save the promisee, that is the indemnifier undertakes to save the promisee, that is indemnified, from any loss caused to him by the conduct of promisor himself, that is indemnified himself, or the conduct of any other person. Sir, it is a situation where one person saves another person from any future loss. And this loss may be caused by the conduct of the promisor himself, or it may be done by the conduct of any other person. What is guarantee contract, sir? Guarantee contract as defined under section 126 of Indian Contract Act, and it is based on what, sir? It is securing the creditor. The most important point of guarantee contract is it secures the creditor. What? Who is secured, sir? Creditor is secured. Who is providing such security, sir? Surety. When surety is liable, sir? In case of debtor's default to perform his promise. In case of debtor's default to perform his promise. So in case of guarantee contract, the most secured person is creditor, and the person who is going to lose under guarantee contract, he is not going to gain anything in the guarantee contract, is the surety. And who will enjoy the credit, sir? The credit will be enjoyed by debtor. He will get loan, he will get goods on credit, he may get employment on based on guarantee by surety. So he is the most benefited person. He is debtor. He will enjoy the credit. Parties. How many parties are there in indemnity contracts, sir? There are two parties in case of indemnity contract, that is indemnifier and indemnity holder. That is promisor and promisee. In case of guarantee contract, there are three parties. They are principal debtor, creditor, and the guarantor, also known as surety. Next, contracts. How many contracts are there in case of indemnity contract? So there are only one contract in case of indemnity contract, and it is between indemnifier and indemnity holder. How many contracts are there in case of guarantee contract? So there are three contracts in case of guarantee contract. It is between debtor creditor, creditor surety, and surety and debtor. What about liability? Who is liable under breach or if the event happens? The liability of promisor, that is indemnifier, is primary and absolute towards indemnity holder. The liability of indemnifier, that is the promisor, is primary and absolute towards indemnity. Who is liable in case of if the event happens, sir? If you have taken any insurance related with property, then if any event occurs related with the property and your property is destroyed, then in such case, insurance company, if you have taken insurance and if you are paying regularly, your policy is on, it is continued, then in that case, insurance company's liability is primary. It will help you out to compensate your losses. Like this, insurance company as a promisor, as an indemnifier, as having primary and absolute liability towards the insurance policy holder, that is indemnity holder. Promise is the insurance company is liable to pay to the indemnity holder, that is policy holder, in the event if any loss is suffered by the promise. What about the liability of principal debtor in case of guarantee contract? So the liability of principal debtor is primary. He is the first person who is supposed to pay, as the loan has been enjoyed by the goods on credit has been enjoyed by debtor. He is going to use that all things, all stuff. So his liability is primary, while the liability of the surety is considered as secondary and conditional. The surety is liable only if the principal debtor makes any default or if he fails to pay his liability. If debtor does not pay, then only the surety is supposed to pay. So his liability becomes secondary and conditional. What are the objects in both the contracts? For what purpose basically such contracts are framed? The object of such contract is to protect the indemnified against the future loss, possible loss, probable loss through reimbursement of the loss. So basically in case of insurance contract, it is also known as indemnity contract, or we can say compensation contract. But basically in insurance contract, we don't know whether the event happens or the event does not happen. If, say, for example, for a factory, you have taken an insurance, fire insurance, to save your factory from fire. If fire occurs, then only insurance company is liable to pay you. That is all about future. We don't know. Such event may happen or it may never happen for the lifetime. So it is totally depending on happening of the event. So such protection is provided by the insurance company, that is the promisor, to the promisee to save him from future losses. Whatever losses, if it is suffered by promisee, it will be reimbursed. It will be paid as an indemnify, as a compensation of loss to the promisee by the promisor. What about the object of guarantee contract? The object of such contract is for the security of the creditors. It provides security to the creditors, is what we have studied at the initial stage. The most secured person in case of guarantee contract is creditors for assuring his payment, for assuring his. So there is an assurance to the creditor about the payment. Two persons are providing assurance about the payment. First person who is having the primary liability is debtor. Debtor is assuring first that I will pay all the amount which is outstanding from my side in future. And if debtor makes any default, then the other person is also ready, who has given the guarantee as a guarantor. He is also supposed to default of debtor. So the most secure person is creditor. Creditor gets secured. That is the main object. And how we get secured? With the surety, basically with the guarantee given by the surety. Request. Whether any request is needed in both the contracts, sir. In indemnity contract, no request is needed, but in contract request is must. Basic points. Indemnifier acts independently without any request of the debtor or the third party. Insurance company won't require any request made by the outsiders, by the third parties, by the external sources. They don't need any request. Say for example, promisee wants to take any property insurance, he will apply to take property insurance. And if indemnifier, that is the insurance company, if it feels that it must provide insurance to the promisee indemnified, then it depends on totally on the insurance company whether to provide the insurance or not. No request is needed from any third person. But in case of surety contract, suretyship contract, that is guarantee, surety must give guarantee at the request of principal debtor only. Say for example, debtor wants goods on credit from creditor. Debtor wants goods on credit from creditor. And creditor demands from debtor, I will provide you goods on credit, but bring one surety or bring one guarantor. I will provide you goods on credit. So in such circumstances, what debtor will do? Debtor will try to convince, debtor will try to request maybe his friend to become a guarantor, to become a surety. Please you become surety. Please you come with me, become guarantor. And if you become guarantor in the particular transaction, I will get goods on credit or I will able to get loan. Such request is must. Interest. Whether any interest is attached with both contracts. Sir, in case of indemnity contract, there is an interest which is attached, but there is no substantial interest. No interest is attached in case of guarantee. Over here, what is the meaning of interest? That is very, very. Whether any source of income is going to be earned by the person who is giving any security. Who is giving security in case of indemnity contracts? Sir, giving security. Who is giving security in case of guarantee contract? Surety. Basics should be clear to you. Then only you will be able to write down the answers perfectly. So the promisor has some interest in the contract apart from indemnity. Promisor has some interest means insurance company. If I talk about insurance, will receive premium. That is the interest of insurance company. As and when premium will be paid regularly on time, protection will be provided to the other person, promise. So some interest is there, and interest in the source of income is premium for the insurance company. You are supposed to have something, you have provided something to the promise. Promisee is going to pay something to the promisor for providing protection over here, and that is considered as premium. So it's a source of income for insurance company as a promisor. So there is some interest related with indemnity contract, and the interest is who is having the interest? Sir, promisor is having interest in the contract. He is going to earn something from such contract. So both are benefited. Promisor and promisee gets protection. While in case of guarantee contract, what happens in the particular contract? So the surety has no substantial interest in the contract apart from promise to pay the debt. Surety is not going to gain anything from such contract. He is providing a free service to his friend, maybe his friend as a debtor. He is providing as a service, as a guarantor to his friend debtor, that if he does not pay, he is going to pay. He just makes promise on behalf of debtor towards creditor that if he does not pay, if his friend does not pay, debtor does not pay, then guarantor is ready to pay. So he is having no substantial interest. He is not going to make any income. There is no source of income of guarantor in such particular contract. Number 8, performance. The liability of indemnifier arises only on the happening of conditional event. The insurance company is going to pay only if the event happens. If you have taken vehicle insurance and if any accident happens with that vehicle, then only they are supposed to pay you as a compensation. Then only the liability arises to be paid. Such protection is given. So it depends on the future. It depends on the happening of the event. Event may happen, event may not happen. So there is no fixed liability. This liability is not fixed. It totally depends on the happening of the event, which is conditional. Which is conditional. But in case of guarantee contract, sir, there is an existing debt, there is an existing duty on either debtor will going to provide the debt, release the debt, or if debtor does not release the debt, then surety is supposed to release the debt. So there is an existing liability. If you have taken loan, you are supposed to repay the loan. If you have taken any goods on credit, you are supposed to make payment of that credit goods. So liability is fixed over here. It does not depends on the happening of the event. Your debt is fixed. You have taken loan, you are supposed to repay it. So you have to perform. Your performance is fixed. Your promise is fixed. Your debt is fixed. You are supposed to perform under such contract. Either debtor will perform, and on default of debtor, surety is supposed to perform. Competent. We know what is competent towards the party of the contract. What is competency? We already have learned. Section 11 of Indian Contract Act provides such information that both the parties must be competent to enter into a valid contract. What is competency of contract, sir? It is very easy, sir. The person should be a major person. He should be of sound mind and should not be disqualified by law as per section. Then only he can enter into a valid contract. We have studied in detail in Unit 1 related with capacities of parties, competencies of parties. What about a guarantee contract, sir? The principal debtor may be a minor person. We have seen in the essentials basically based on a guarantee contract. The principal debtor may be a minor person, but under such cases, surety will have what? Surety will have primary liability. He is the only person who is liable in such case, because a minor person cannot create a debt contracts. He is not able to have liability. He is not considered mature enough to have liability because he does not have any source of income in that case. That is the basic reason. So he is not at all liable for any debts. So a minor person is not able to have debt contracts. So in such circumstances, if he is and debtor is enter as a minor person in the contract, then surety's liability is primary liability, while the surety and creditor must be competent to enter into a contract. They must be a major person in such circumstances. This is the only arrangement which is a valid arrangement in guarantee contract. In other situations, if we reverse the situation, sir, if a creditor is minor and surety and debtor is major, such arrangements are invalid. Other arrangements are not valid. Last point, right to sue. It's right to file a case. Whether in case of contract of indemnity, the person has a right, the promisor has a right to file a case directly in his own name, or what about guarantee contract? Whether the surety will be able to file a case in his own name towards debtor if he makes default. What about the right to file a case against another? Who is having such right or who is not having such right? That discussion is over here. In contract of indemnity, the indemnifier cannot sue the third party in his own name unless there is an assignment, that is transfer of right to sue in his favor. Now, this assignment is not the assignments which are given to you at college level. This assignment over here is, that is, I have clearly mentioned transfer of right to file a case against another person. That is over here the meaning of assignment, which you have already studied in uh, semester 1, or it may be in FI BCom you have studied related with insurance, nomination and assignments. You have studied that topic over there. That is assignments over here. Now, the promisor, indemnifier means promisor cannot directly sue to third party in his own name. Let me provide you one example. You have taken a vehicle insurance and there is an accident with your vehicle of third party. And what will happen, sir? Third party will be uh, he is responsible for such accidents, say for example, and promisee is trying to recover his losses. If he has taken vehicle insurance, he will directly claim towards insurance company that on a particular spot I met with an accident and third party is liable for that. So I demand compensation from insurance company as an promisee, right? So insurance company will pay me, my claim will be settled down. I am happy now. My losses are recovered. But over here, the fault was, say, for example, of third party, and uh, third party is exactly responsible to pay the loss. But instead of third party, insurance company is paying. Now, insurance company has done nothing in such case. It is the loss occurred by third party. Now, insurance company wants to recover this loss. How it can recover this loss? It is a total loss to the insurance company. If insurance company has 50,000, paid 50,000 to promisee to settle the claim. Now, what about if insurance company can file a case on third party to recover the losses which has been borne by insurance company? Yes, sir. Insurance company can file a case on third party. First right to file a case is with promisee. First right to file a case is with promisee. So promisee can directly file case against third party in his own name because the event is occurred between the two parties, promisee and third party. But if promisee does not use his right, he can transfer his right to insurance company, and insurance company can claim the compensation from third party. So like this, insurance company can recover its losses. What about contract of guarantee, sir? In case of contract of guarantee, if the principal debtor fails to pay, if the principal debtor fails to pay, surety discharge his debt, and the surety discharge his debt, the surety can proceed against the principal debtor in his own name. No such assignments is required. Guarantor is not supposed to demand any assignments towards from creditor. He has a right, he can directly also file a case against debtor to recover his losses.